Hi guys, such Mobim here again. Did you know that if you buy a land or you sell a land without the consent of the governor, that transaction is null and void? And that is with the backing of the Land Use Act of 1978. In today's video, we are going to be delving right in, to explain this particular provision of the law as stated in the subsections of Section 22 of the Land Use Act of 1978. Now, let's talk about the Land Use Act and the provisions generally. This particular law, invests or vests all the right, almost an absolute right on the governor of a particular state to administer land. What it means is this: the governor of the state is the landlord. By landlord does not mean he owns that particular land. What it means is he holds the right to administer, land for public interest, the purpose, of the masses. What it means is this: the governor gives out land to people, leases out land to people. He controls who owns what and who gets what for the purpose of the public. That condition is quite important as far as this law, is concerned. Now, diving right in, we are talking about the governor's consent, granting, consent on transactions, around lands with statutory, rights of occupancy or customary rights of occupancy. Now, the subsections of the section 22 of this particular act, explains everything, summarizes everything, that it is illegal to transfer rights of ownership from one person to another without the consent of the governor. Now, the consent of the governor actually, is more like a receipt on approval, a document, stating that the governor is aware that this land that was belonging to Mr. A has now been transferred by any means, either by way of deed of conveyance, assignment, lease, mortgage, to Mr. B. That is just what it simply means. But the problem of this particular provision is this: ordinarily, it is fine, you understand, since the governor is the landlord of a particular state. But the problem is the bureaucracy in our system. Sometimes, even when land, and then we know the problem of the fact that lands are categorized into, say, two places. One is the area that is acquired by the government, where the government has shown immediate use for, you understand, and then the other, side of the category, is freehold, where the government does not have any immediate use. Now, such lands are still being managed by, the community people, individual owners, especially lands in the villages where people are settling, you understand. So people still should reserve, so to say, some rights to say, okay, my son, you are inheriting my land, or I want to sell this land, for my personal need, you understand, to provide for my personal need. So would these people holding rights over freehold lands, need to go through the bureaucracy just, for their own need? And also considering the fact that most lands that are actually under freehold are not fighting against public interest, you understand. And also, the deals between these private people on freehold land most times are done without any issues, amongst the parties. So now, this is actually the problem of the provisions of, the section 22 of the law. Now, the Supreme Court, one of the functions is to close some gaps, in our constitution. Now, the Land Use Act also is a law of the Federal Republic of Nigeria, of course, which has its own, loopholes and then, issues, gaps as well. We are going to be discussing some important or infamous court cases as far as transferring ownership and seeking, consent of the governor is concerned, and how the Supreme Court gave ruling, to close some of these gaps. Number one on the list is actually a very notable one, infamous, for its rights, and has stood as a benchmark for a long time. That is the case between the Savannah Bank and the Agilo. A little background story, to this particular case. It happened in 1989 between Mr. Agilo and the Savannah Bank. It happened that a certain Mr. Agilo, took loan from a bank, the then bank, Savannah Bank, and used his property, for collateral, you get. And after a period of time, when he could not meet up with the debt he was owing the bank and could not repay the money, of course, ordinarily, the bank should have the right to auction that particular property and then raise money for other businesses. Now, upon trying to do this particular thing, to auction this particular property, the Mr. Agilo sued the Savannah Bank in question, And funny enough, he revoked his bone of contention. His argument was the fact that the governor's consent was not, sought um, during the process of the transaction, and therefore he denied Savannah Bank that Savannah Bank, the transaction is null and void, and Savannah Bank does not have any rights over that land, whether to auction or to do anything with the land. So to say, our man is using his number six, fraudulently. Of course, it's obvious, no denial, transactions were actually carried out, but because he could not meet up with the debt, he tried, to use a loophole already existing in the Land Use Act for his own purpose. Funny enough, he took the court. He sued Savannah Bank at the High Court, Federal High Court level, Abuja. He won. Savannah Bank appealed that particular rule, and funny enough, it was dismissed. So Ajilo won again. Then, Savannah Bank now went to the Supreme Court, and before you know it, a ruling was made on this particular case, stating and categorically stating. Now, it is one thing for the laws of the land to have loopholes. It's also another thing for the Supreme Court, in an attempt to close this gap, now cause more problem, more, confusion, and leave more loopholes for interpretation. Now, on the Savannah case, Savannah versus Ajilo case, the Supreme Court now categorized, the two rights of occupancies, the statutory right and the customary right, and now said that any land, any transaction at all that involves transference of ownership from one person to another without the consent of the governor, whether statutory, whether customary, freehold, whatever it is, any transaction you are doing on land without the consent of the governor is null and void. You know what that means? Now, this frustrated the system. For those who are learned, who wants to do things the way they should be done in terms of real estate business and all, you will need to pass through the bureaucracy, even for land that do not directly need the consent of the governor. For instance, land in the villages between a brother and a father. Father wants to transfer ownership to his son in the village, and this is an ancestral land. By this particular ruling, it means that transference of ownership is null and void as far as the law is concerned. So the son will now need to get a certificate of occupancy, or the father needs to get a certificate of occupancy, pass through the necessary procedures, and then get the consent of the governor before the son legitimately starts to own that particular land. So that is one of the issues created by this first law, and your guess is as good as mine. People started milking this particular loophole over the years. There were cases of people who were now fraudulently going back after a transaction. They will go back to sue the eventual buyers of such properties, to collect back their land. And because this is the ruling of the Supreme Court, they were referencing the Savannah versus Ajilo case, and they were winning. But over time, because it grew as a pattern, you understand, it was now discovered or explicitly brought out, and they noted that, okay, fine, because of this pattern, this is what happens. The fact that the governor's consent was not sought, during a transaction process, do not negate the fact that a transaction was done. Because in the transaction, you'll be having things like the power of attorney, you understand, and then some other documents showing, even witnesses showing that so amount was paid for this particular land. But previously, the cases where that transaction does not involve the consent of the governor, it will render null and void. But this time around, the rulings were now saying that, considering the fraudulent patterns over the years because of the Savannah versus Ajilo case, the rulings were now stating, that the fact that the transaction does not include, or that the transaction document does not include the governor's consent, does not negate the fact that the transaction was actually done. However, it was stated that such transactions are termed incomplete and not null and void. Now, this continued for some time, and it was more like stopping businesses were unsure, real estate companies were unsure, individual investors were unsure, about investing and then buying transactions in land and all, up until a certain case, between Yakubu versus Ogbaje. Now, in this particular case, it caused a new level, a paradigm shift in the system. It was that time when it seems as if the Supreme Court has actually understood over time the happenings in the land and what was meant to be. Finally, they gave a ruling between the Yakubu and Obaje in this particular case, still having almost the same background with the Savannas. But this particular one now, it's in the ruling, it was spelled out specifically that the consent of the governor is not needed in transactions involving two private people over a private land. Now, by private land, I'm talking about lands under freehold. So this is not, it does not have a statutory right of occupancy or customary right of occupancy. By customary, I mean the one actually issued by the local government chairman of where that land is. Now, for freehold lands or private lands, they do not need the consent of the governor, before transactions are made, on transference of ownership. So that was a breakthrough in the real estate of this nation. Although this particular court case lingered from a period of, say, 2001 when it was first filed, 2005 when it went to the appeal court, and then recently 2017, when Supreme Court now had its final ruling on it. Now the point is this: there has been two different rulings, on a particular subsection or interpretation of the law. Now what it means is this: although you have two rulings and then they both have their own rights, the latest most of the time, you understand, is considered to append or supersede the previous one. So the Yakubu case, is more superior and also supersedes the Savannah versus Ajilo case. Now, in as much as this was considered a paradigm shift and all, it will also need people's, orientation, people to be, informed about, such provisions, of or interpretations of the law before they can now understand, what to do. Now, following the success, the landmark judgment on the Yakubu versus Obaje case, you notice that there are several cases that actually come up over the years between 2021 and presently. You understand, challenging, the rights to seek governor's consent, of course, referencing the Yakubu Obaje case, and then they are winning. So now, how does this particular happenings, or everything I've been saying like this, how does it affect you? What it means is this: you need the consent of the governor only for land where you have statutory right of occupancy. That is to say, for land that's actually acquired by the government. That is to say, if that land, you bought that land with the consent of the governor, if that land has a C of O. If you have a land that has C of O, you cannot sell that land without the consent of the governor. You cannot transfer ownership without the consent of the governor. You cannot lease that land, for mortgage or whatever without the consent of the governor. That is what it means. However, for private land, categorized under freehold zones, and where you are not having issues, the person you are dealing with, or you're having transactions with, that land does not need the consent of the governor. For instance, a father does not need the consent of the governor to transfer right of ownership to his son. That is just an example, of a exceptional cases like this between private owners. That basically is what the judgment of Yakubu versus Ogbaje entails. You understand? It kind of narrows it down. It's only talking about the freehold zones. It's not talking about the areas acquired by the governor, where the governor is actually issuing land. You understand? Issuing, ownership or occupancy, right of occupancy over land. That simply is what it means. Now, by this video, I hope I've been able to enlighten you and not to confuse you about some of the provisions of the law, supported by cases, court cases and rulings of the Supreme Courts of the land, and also give you some personal opinions about these particular issues, and also to advise you better on how to go about your land transactions. You want to buy, you want to sell, what category is the land, so that it will help you make better decisions on what to do, with your money or with your land, as the case may be. So, like as usual, subscribe, follow, engage us, and then we'll be happy to follow you up. It's such moving here again, your favorite surveyor and Rito. Thank you and bye for now.